Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, and welcome to this episode of Triage. My name is Rebecca Schaefer, and I'm a partner in the firm's Research Triangle Park office. My practice focuses on healthcare regulatory and transactional matters with particular focus on supporting academic medical centers.
I'm Victoria Hamscho. I'm an associate in the firm's Washington, D.C. office, where my practice focuses on healthcare policy and regulatory matters impacting healthcare providers and other stakeholders. In this episode of Triage, we will provide an update on next month's Supreme Court oral arguments in California v. Texas, where the court will review the constitutionality of the Affordable Care Act, or ACA. We will be discussing the potential impact of the Supreme Court's decision and the current Republican and Democratic plans to address its impact in case the entire ACA or major parts of the law are overturned.
As Victoria mentioned, the Supreme Court will be hearing oral arguments in California v. Texas on November 10th, a week after the 2020 election. At issue is whether the ACA's individual mandate to maintain health insurance is unconstitutional, and if so, which parts of the law are required to be struck down with it. It is widely recognized that in the 11 years since its enactment, the ACA has vastly reshaped our healthcare system. The law was enacted with the goals of increasing access to healthcare coverage and quality while reducing healthcare costs. The landmark statute also included a wide variety of interrelated and sometimes standalone programs and changes intended to improve our healthcare system. To expand insurance coverage, the ACA promotes employer-sponsored coverage, provides for the expansion of Medicaid, and facilitates access to private health insurance through marketplaces. In turn, the ACA generally requires individuals to maintain health insurance coverage or make a shared responsibility payment to the IRS, called the individual mandate. Back in 2012, the Supreme Court heard a constitutional challenge to the individual mandate, where the court upheld the mandate as a constitutional exercise of Congress's taxing powers. As listeners may remember, in National Federation of Independent Business versus Sebelius, the Supreme Court held that the mandate could be read as an option to maintain health insurance or pay a tax, reasoning in part that the penalty-produced revenue for the government was paid into the Treasury by taxpayers and was determined by factors like taxable income, dependence, and joint filing status. In 2017, after several attempts to repeal and replace the ACA, Congress, through the Tax Cuts and Jobs Act, set the penalty for failing to comply with the individual mandate at $0. Shortly thereafter, 18 states and 2 private citizens brought suit in federal district court, arguing, in part, that the individual mandate is no longer constitutional because it cannot be read as an option to purchase insurance or pay a tax. They further argued that the individual mandate is inseverable from the rest of the ACA, requiring the entire law to be struck down. A federal district court held that the amendment setting the penalty to $0 rendered the mandate unconstitutional and that the mandate could not be severed from the rest of the ACA. Last year, the U.S. Court of Appeals for the Fifth Circuit affirmed the district court's decision that the individual mandate is unconstitutional because it can no longer be justified under Congress's taxing power. The Fifth Circuit found that the tax attributes that the Supreme Court previously relied upon in upholding the mandate no longer exist, reasoning that it no longer produces at least some income for the government, and as a result, it is no longer paid into the Treasury by taxpayers, and the amount is no longer determined by such familiar factors as taxable income, number of dependents, and joint filing status. The Fifth Circuit, however, vacated the district court's ruling that required striking down the rest of the ACA.
Accordingly, this time around, the Supreme Court will be reviewing not only if the individual mandate is unconstitutional, but also whether the mandate is inseparable from other parts of the ACA, requiring those parts to also be struck down. The impact of the Supreme Court's decision will therefore depend on the scope of its ruling. If the Supreme Court concludes that the individual mandate is severable and all other parts of the ACA are allowed to stand, the impact of the decision will likely be minimal. In this regard, we will largely be where we are right now, as the individual mandate share responsibility payment has not been collected for years, either because of the challenges to its constitutionality or the fact that it is currently set at $0. However, if the Supreme Court signed that the individual mandate is not severable from some or other parts of the ACA, the impact of the court's decision could obviously be enormous. It is possible that the court could conclude, as the district court did, that the whole ACA needs to be struck down. This would impact not only the ACA provisions directly aimed at expanding access to coverage, but also a myriad of other programs and reforms implemented under the statute. Over the past couple of weeks, the potential impact of the Supreme Court's decision in California v. Texas has been a key point of discussion amongst Congress and the presidential campaign, particularly in light of the passing of Supreme Court Justice Ruth Bader Ginsburg and this week's confirmation of U.S. Court of Appeals for the Seventh Circuit Judge Amy Coney Barrett to fill the vacancy. Judge Barrett's recent confirmation as a devout Catholic and former clerk of Justice Scalia has solidified a conservative majority in the Supreme Court and will decrease the likelihood of 5-4 splits that have until now favored more centrist and liberal decisions, including those pertaining to the constitutionality of the ACA.
It has been estimated that over 20 million people could lose health care coverage if the ACA is overturned. A sharp increase in uninsured and underinsured would very likely increase the amount of uncompensated care that healthcare providers, especially safety net providers, must absorb. An Urban Institute study estimated that providers' share of uncompensated care could increase 109.2% over a 5-year period, even if the government funds uncompensated care at pre-ACA levels. Providers could therefore experience additional financial stress, particularly at a time when the provider community and the populations they serve are still grappling with the ongoing economic and health impacts of the COVID-19 pandemic. Depending on the scope of the Supreme Court's decision, additional provisions that could be impacted include consumer protections, such as those for people with pre-existing conditions, provisions related to or impacted by the ACA's Medicaid reforms, such as 340B drug pricing program expansion and eligibility, and provisions related to Medicare and healthcare quality, such as the Medicare Shared Savings Program and Hospital Value-Based Purchasing Program. The ACA also established the Centers for Medicare and Medicaid Innovation, or CMMI, within the Centers for Medicare and Medicaid Services, which test new ways of paying for and delivering care in Medicare, Medicaid, and the Children's Health Insurance Program. CMMI has funded a broad range of programs which could also be impacted if the ACA is overturned.
Over the past few months, President Trump and Joe Biden have outlined aspects of their healthcare plans ahead of the election, which are aimed in part at addressing the potential impact of the Supreme Court's decision in California v. Texas and proposing new healthcare reforms for the years ahead. In a statement regarding the Fifth Circuit's decision in Texas v. United States, President Trump stressed that the decision would not alter the current healthcare system, adding that his administration would continue to work to provide access to high-quality healthcare at a price people can afford, while strongly protecting those with pre-existing conditions. To this end, President Trump recently signed an executive order titled An America First Healthcare Plan, which broadly outlines some of his administration's healthcare priorities if he were to be reelected. Some of the priorities outlined include ensuring that Americans with pre-existing conditions can obtain insurance of their choice at affordable rates, and expanding access to and options to affordable healthcare. The executive order also describes other priorities, such as expanding access to affordable medications, promoting medical innovation, and improving quality of care. Joe Biden, in contrast, has vowed to protect and build on the ACA. Reacting to the Fifth Circuit's decision in Texas v. United States, for example, Joe Biden expressed his view that we have to protect the progress that we've made and show up to the polls to defend the Affordable Care Act. As part of his healthcare plan, Joe Biden has proposed offering individuals a public health insurance option while reducing the Medicare eligibility age to 60 instead of 65. Individuals who are at least 60 would have the option of opting into Medicare, the public option, or a private health insurance plans of their choice. In an effort to build on the ACA, he has also proposed to increase the value of ACA subsidies and provide individuals in states that have not expanded Medicaid premium-free access to the public option. The states that have expanded Medicaid would have the option to transition their Medicaid expansion population to the premium public option. No matter the results of the election, the administration and Congress in office in 2021 would likely need to address the impact of the Supreme Court's decision in California v. Texas, particularly in light of the public reaction to the decision and the context of the ongoing impact of the pandemic. Depending on the new Congress, this could open the health policy debate and bring about healthcare reform in the years ahead. If there is a full Democratic sweep, for example, where Joe Biden is elected and Democrats control both the House and the Senate, this would create the most significant practical opening for comprehensive reform. Consistent with the Biden plan, the likely approach could be to protect and expand the ACA's foundation, particularly in response to the Supreme Court's decision in California v. Texas. This could entail building on the ACA if key parts remain, such as by increasing the value of the ACA subsidies, or re-implementing at least a nominal individual mandate tax, or otherwise enacting similar concepts if the ACA were to be struck down. If, however, Joe Biden is elected and we have a steady state Congress, Any compromise would likely depend on the extent of the majority in the Senate and the dynamics between the branches of government, with compromise most likely to be reached on areas where there may be bipartisan interest, which could include measures to stabilize the healthcare system post-California v. Texas, as well as healthcare priorities that have gained traction in recent years, such as addressing medical surprise billing, price transparency, and drug pricing reform. Similarly, if President Trump is reelected, the negotiation range on these priorities will likely depend on the majorities in Congress. If Republicans remain in control of the Senate, policy proposals will likely be responsive to the public reaction to the Supreme Court's decision and the need to address the ongoing impact of COVID-19, with compromise most likely to be similarly reached on areas with bipartisan support. If President Trump is reelected and Democrats control the House and Senate, it is possible that more comprehensive healthcare reform bills may be introduced and advanced in Congress to respond to California v. Texas and the pandemic. Given the possibility that these could get vetoed, however, the prospect for broad-based reform would remain limited. However, it is possible that these proposals could serve as a foundation of the next iteration of healthcare reform policy in the years ahead.
Thank you for listening to this episode of Triage on the potential impact of next month's Supreme Court oral arguments in California v. Texas and the decision that follows. As Victoria mentioned, no matter the results of the election, the administration and Congress in 2021 will likely need to address the outcome of the Supreme Court's decision, which could have profound implications for providers and other stakeholders across our healthcare system. Interested parties should consider the potential impact of these developments, and our healthcare and FDA practice and our public policy and law practice regularly advise clients on healthcare legislative and regulatory matters and are able to assist in this regard. Thank you for listening to this episode of Triage in California v. Texas and the future of the ACA. Please do not hesitate to contact us if you have any questions.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.